Mr. Hannafy? Good morning. You may proceed.
May it please the Court, good morning. My name is Joe Hannafy, and I represent the appellant, Candelario. In this appeal, the core argument is that defense counsel had the duty to create a jury question on the issue of the defendant's mental impairment. The Street and Westmoreland cases tell us
what kind of evidence did he have to create this jury issue with?
He had an expert, a neuropsychologist who had done a series of tests on Mr. Candelario. He had interviewed him on 2 separate occasions and had tested him substantially. I think there were 8 or 10 tests that were conducted. He had interviewed Mr. Candelario's family. He had reviewed all the medical records that were available.
What was his conclusion?
He concluded on the issue of mental impairment, he concluded that Mr. Candelario suffered from frontal lobe deficit disorder, and that frontal lobe deficit disorder affects an individual's ability to control his impulses, affects his ability to exercise restraint or to inhibit antisocial behavior. This was a diagnosis that he had given. It was a diagnosis that was demonstrated that Mr. Candelario was in a constant state of an impaired mind. He opined that the frontal lobe deficit disorder was attributable to either a blow to the head, which the medical history demonstrated Mr. Candelario suffered from, or that it could have been genetically based, or that it could have been the result of some in utero trauma. There was also history that Mr. Candelario's childhood, and even during the pregnancy of his mother, that there was abuse in the family. So he had a history of and testing that led him to that diagnosis. That diagnosis was then compounded by the fact that Mr. Candelario was a heroin addict. The records were replete with facts regarding Mr. Candelario's heroin addiction. Dr. Spears, the defense expert, would have testified that heroin attacks, if you will, the frontal lobe and exacerbated and already impaired frontal lobe.
Mr. Hannafy, I'm sure you're familiar with the judge's decision in ruling on the motion for a new trial. Correct?
I am, Your Honor, yes.
Could you help me? I understand what's in the record about what the defense expert had available to him, but could you address some of the quite salient points that the judge seemed to say, namely, this was tactical, which, as you know, puts it into a different category because it would have made, the defense case so vulnerable, opening up the door for all kinds of attacks.
Yes, thank you. The trial judge, in his ruling, believed that it was a tactical decision.
Entered into, as I understand it, with after extensive conversation with the defendant.
There was a letter that I obtained from a defense counsel where he talked about having consulted the defendant. Right. I talked with the defendant. He had prepared an affidavit that's in the record that he didn't even understand what mental impairment was. It was never discussed with him, and I trust that that's accurate because it's a concept that not everyone is familiar with. So I acknowledge that that's what defense counsel said, I question whether there was any ability on the part of Mr. Candelario to even understand it.
But as to the tactical choice?
The tactical choice, I think, was error. I think there was no choice that the defense counsel could have made. He did not call any witnesses. He rested after the defense, or excuse me, after the Commonwealth rested, and simply relied upon his brief cross-examination of a couple of Commonwealth witnesses, and in his closing argument attacked premeditation and a cruel and extreme cruelty or atrocity, which is exactly what mental impairment would have attacked had he raised that, brought that evidence into court.
But isn't that a decision, whether you simply, this was a tough case for the defense lawyer, there were eyewitnesses, so his choice is either to try to negate the elements of first degree to try to make it a second degree, or to go with a mental impairment defense, and he decided that he had more, given his expert, as I understand it, was not as strong as you indicate, but was somewhat wishy-washy on his opinion. So he made the choice to try to reduce it from a first degree to a second degree. I mean, with eyewitnesses, there's not too much you can do.
The only thing he could do was attack premeditation and extreme cruelty or atrocity to get to second degree. The defense counsel, if you'll excuse the tortured analogy, made a bet for second degree murder, and he didn't play his only card, which was mental impairment. That he argued lack of premeditation and lack of extreme cruelty or atrocity, asked for a judge's instruction on a Gould instruction, and was denied it because there was no evidence that there was mental impairment for the jury to consider.
But as, and correct me if I'm wrong, but as Judge Cowan mentioned, his own expert was a little wishy-washy, and the Commonwealth, was in possession of expert evidence, or evidence from experts that seemed to indicate that when they examined him, he attempted to fake it.
If I may.
And they would come forward with that, would they not?
They would have.
And,
I would say
that would be pretty devastating.
As I indicated at the beginning, the core argument here is mental impairment. Dr. Spears also offered an opinion on mental illness, on a McCool standard.
Right.
And he offered the opinion that Mr. Candelario was suffering from psychosis that was borderline paranoid schizophrenia. But he also said that because of that condition and because of the frontal lobe deficit disorder that he clearly diagnosed, the only thing that may have been wishy-washy was the mental illness, the McCool standard. But as far as the mental impairment, he was solid on it. I had him prepare an affidavit that he did. It's in the record that indicates that he was strongly prepared to argue that Mr. Candelario suffered from mental impairment, which was made worse by heroin addiction. Had it been attacked by the Commonwealth experts, the records themselves would have provided an arsenal for defense counsel on cross-examination to establish that there was strong evidence of mental impairment.
What do you think a jury's reaction is going to be on hearing that somebody killed himself because of mental impairment made worse by voluntary consumption of heroin? Do you really think that that's a good tactical choice?
I think it was the only tactical choice in this case because he had no other defense to raise.
Well, no, but he did, and that seems to me there were defenses on the facts. That he arrived at the house in a perfectly calm condition and with a lot of people there, that this was a very sudden thing, a sudden impulsive thing, so he tries to defeat a theory of premeditation. And the argument that is still being raised here, that two quick shots are not, do not make out a case of extreme atrocity or cruelty. I mean, the case was defended on theories. They just didn't happen to work.
They didn't work because he didn't have mental impairment in his quiver. You just said that his actions that day were impulsive. That's exactly what mental impairment speaks to. This would have enhanced.
But the facts made it look impulsive without getting into issues of mental impairment. And as it's been raised, if he had started putting in Dr. Spears, the jury was going to hear evidence about the defendant faking symptoms, which is a potentially catastrophic thing for the defense.
The jury also would have heard that he had a diagnosed head injury, that he had suffered from seizure disorder, that he had an extensive criminal history, that he was suffering from, the Bridgewater State Hospital diagnosed him as having a heroin addiction. He was observed at Bridgewater suffering from heroin withdrawal. All of these things would have come into evidence had he put on mental impairment as a defense. And his heroin abuse and his heroin addiction would have been part of the record at that point. The other point I would ask the court to consider this morning is that the cross-examination of the Commonwealth's experts who
excuse me, let me just go back 1 second. You keep talking about mental impairment made worse by voluntary drug abuse, heroin, but there was no evidence at the trial that he had taken the drugs, if he had, before the killing. The evidence was from his, I forget it was his brother or his friend who was with him that night, said that he was taking drugs that night, but there was no evidence that he had taken them before the killing.
I think the brother testified he didn't know when he had taken it, but I would submit, Your Honor, that Dr. Spears would have been able to offer his expert testimony based upon a DYS versus a juvenile, wherein he would have been able to rely upon the medical records that were replete with information about heroin addiction, that he suffered from a 20-bag-a-day habit, that he was observed in heroin withdrawal shortly after his arrest, which would have put significant amounts of heroin in his system that was flooding the frontal lobe.
That's really going to help you with the jury.
Well, Street and Westmoreland tell us that defense counsel cannot shy away from being an advocate and not play role of the juror. He had the opportunity to present an explanation to the jury as to why someone would act in such a hideous manner. And without that, the defense was empty. It was an empty shell. This would have given it real traction. It would have enabled the jury to consider how anyone could behave in such an atrocious way, and they might have come to understand, well, this poor fellow didn't have the ability to control himself, that he suffered from physical impairment in the mind, a mental impairment that made it impossible for him to control himself. We're not talking about McCool. We're not talking about not guilty by reason of mental illness. We're talking about second-degree murder. I submit that the defense counsel had the duty to present that defense because he had no other defense. It would have enhanced what he had argued in closing argument. And not having used that, he violated what Street and Westmoreland tell us, that you cannot play the role of juror and assume how they're going to rule on it. It's advocacy.
You're using Street and Westmoreland to make an argument, essentially, that defense attorneys should never pick one tactic rather than another.
Well, not exactly. I think the case law also tells us that if you have a meritorious defense like self-defense, that you don't, it's a clear tactical choice to avoid damaging that viable defense by putting on evidence of drug addiction or mental illness, which brings with it other matters involving the conduct of the defendant.
Counsel, you were going to talk, I think, a little bit about the defense cross-examination of Commonwealth witnesses. Are you going to mention that?
I had alluded to it briefly.
I thought just before Justice Cowan asked you a question, I thought you were going into some aspects of cross-examination.
I think what I may have been about to say was that if the Commonwealth, and I trust they would have, put on their own experts to attack Dr. Spears, that would have opened up for the cross-examination of those experts everything that was in the Bridgewater records. And in those records, there are, as I indicated, an arsenal of material, of facts that would have bolstered the mental impairment defense. So on the one hand, yes, there was concern. I trust that defense counsel had concern that there would have been evidence offered that Mr. Candelario was not mentally impaired or not mentally ill. But there was also lots of material that could have balanced that.
Mr.
Mr.
Hannafy,
Hannafy, on that issue of him not being able to control his impulse, just if you go over the facts with me just briefly, as I understand it, he shot the girlfriend in the head, and one of his friends was right there, and the friend reached for him. He pointed the gun at the friend, but he did exercise control and did not shoot the friend. Is that correct?
I would say that is correct. It was not a friend. It was a family member of the deceased victim. There was an exercise of control, if you will, at that point.
So what we had then was that your argument would be he was unable to control his impulse with the girlfriend, but he could control the impulse with the family friend.
I think that makes it a jury question. I think because of the strain on him, because of the relationship, that it demonstrates that there was misfire of the frontal lobe at that moment, and that he was unable to control himself.
Mr. Hannafy,
as against that victim.
Did the jury have evidence that he was a heroin addict?
They did not receive that evidence. They could have received that evidence.
But there was nothing in the record that told this jury that this was somebody who was addicted to heroin.
There was nothing in the record that the jury ever received that he was a heroin addict. There was nothing in the record that ever told the jury that he suffered from frontal lobe deficit disorder. None of that went in. This was a damaged man. The jury never heard it. And they relied upon a closing argument that said, please don't convict him of first-degree murder. It's second-degree murder. Please don't convict him of extreme cruelty or atrocity because it's not there. Now, had he put in that evidence, and he could have done so, had he put in that evidence, it would have given that argument weight. And I submit that that was prejudicial constitutional error, and that as a result, the trial judge did not have the discretion to deny the motion for a new trial, and he certainly didn't have the discretion to deny that motion without an evidentiary hearing. And I submit that that was an abuse of discretion that he didn't have. And on that, I will rest on my brief.
Thank you, Mr. Hannafy.
Thank you very much.
Ms. Semmel?
Good morning. May it please the Court. I'm Catherine Semmel, an Assistant District Attorney in Essex County, appearing on behalf of the Commonwealth. I think often when I've come before the appellate courts on an ineffective assistance claim, we've had a very unclear picture of what deliberate choices counsel made and why. And that's not the case here, because we do have a letter from Attorney Andrews, who was the trial counsel, sent to defense appellate counsel in preparation for the new trial motion, where he explains why he made the choice he made and gives this court some salient information. First, that he decided to forego a mental health defense in conjunction with the defendant. They consulted about this and they decided it together. Second, that he made that decision after consulting with the defense expert himself, Dr. Spires, I'm sorry, I'm not sure. And third, that he did so because of the perceived weakness in the expert's opinion. Now, Attorney Andrews doesn't elaborate about those perceived weaknesses, but those are fairly obvious here, and if they weren't obvious, they're spelled out by Judge Welch in denying the new trial motion. He described the expert's opinion as somewhat half-hearted. But in addition to that, it's based on assumptions that were not ultimately borne out on the record, assumptions about drug use. There was no evidence, as the courts pointed out, that he was using heroin before the offense. is based on assumptions that the defendant does not recall the shooting, which is also not borne out by evidence on the record. In addition, the doctor, I think, glosses over a lot of factors that detract from any finding as to mental impairment. There's no documented psychiatric history. The events described by all the
Ms. Samuel,
witnesses.
I don't mean
Yes,
to interrupt you.
That's quite all right.
In looking at your brief in connection with the motion for a new trial, you seem to suggest that the person who had information about the heroin that he had ingested was not, in fact, his brother. Is that a?
I think he's his adopted brother.
Okay.
He grew up in their family.
Okay.
I mean, I hear what you say, and I read it in your brief, and surely it makes sense that the lawyer would be quite concerned about putting this expert on because of what would come thereafter, both on cross-examination and Commonwealth experts that clearly, 3 Commonwealth experts that clearly observed him to being fabricating some of these characteristics. But on the question of mental impairment, that seems a little different. Counsel didn't get into evidence heroin addiction. Clearly could have, I would imagine. He's got his, I mean, he clearly was addicted to heroin. I mean, that appears pretty obvious
Seems
from the
supported by
record.
the medical records, yes.
Yeah. I mean, that certainly could have been gotten in. And I assume better examination, cross-examination of this adopted brother could have also brought that out.
I agree that better cross-examination could have brought out some things from Pedroza, but I think that Attorney Andrews handled Michael Pedroza very adroitly in that he managed to elicit from Michael Pedroza the fact that the defendant had heroin with him that night, the fact that Pedroza knew that the defendant had used heroin that night, and then he left it a little blurry.
How could he get from the brother that the defendant had taken heroin before the murder? If the brother weren't with him, he wouldn't have seen it. It wouldn't have been admissible.
I don't think he could have, which is why I think he did the best he could. He certainly created a perception from which jurors could have deduced, gee, maybe he was using heroin before the shooting. But I don't think that Pedroza could possibly have supported the fact that he actually did.
It just strikes me that it may be a perfectly rational choice to forego completely the use of this mental expert, but then you've got to have a fallback. You've got to have something to do. And I understand the lawyer tried to sort of create the dynamic that suggested that this was a spur-of-the-moment reaction to a huge emotional argument. But surely he could have done more, particularly with the heroin use and the heroin addiction.
Well, I don't think he could have gotten much mileage out of the heroin, assuming that jurors would have taken that in a good light instead of a bad light. But I don't think he could have gotten much mileage if he couldn't show that he was using heroin before the shooting. And even now, the only thing to support that is the defendant's own self-serving affidavit to that effect. So two things. One, I don't think he could have gotten anything particularly helpful about the heroin. The other thing is, it may certainly have detracted from his position in terms of jurors' perception of him that he's a heroin addict. But in addition, I don't think you can shortchange what Attorney Andrews did in his attempt to support a second-degree murder case.
But Samuel, let me ask it to you this way. He says, I made a tactical choice, and as you correctly point out, we know this is not the ineffective where somebody doesn't even consult the expert or doesn't know that he's had that he suffers from any kind of addiction and so on.
Right.
But if you're trying to, if your strategy is, second degree, what did he give the jury that would give it any basis to reach a conclusion that this was second and not first degree?
I think what Attorney Andrews did, and he did this consistently from opening an argument through cross-examination through the close, is he set up a number of events. He emphasized repeatedly there were multiple witnesses to the incident. He emphasized the defendant wasn't angry when he arrived. He wasn't angry when he called the victim over. He got testimony from all the witnesses.
No, I understand that. So what's the triggering event? What's the explanation?
For why he shot the victim?
Yes.
that they were involved in a heated argument, which was described by all the witnesses, that she told him, she didn't want to see him anymore, she wanted him to go away.
No, I understand that. So then,
And that's a trigger, that it wasn't premeditated, that it was a response to their angry interaction. And I think the other thing that counsel really did is he questioned all the witnesses, trying to shorten that time frame between the first and second shot. He got Anna Cardenas, who's the woman in the car that was parked at the stop sign. She originally testified that it was 10 to 15 seconds between the first and second shot. By the end of cross-examination, she admitted that she was probably wrong and it was probably 5 seconds. I think what counsel did is he attempted to show that the defendant didn't go there with the idea of shooting her, that it arose from their fight, and that the shots were fired in quick succession, which of course goes to extreme atrocity and cruelty, and also to and it can also go to premeditation.
Wasn't there evidence from the Commonwealth that he told somebody's aunt, victim's aunt, I think, that in advance, that he was going to kill her?
There was testimony to that effect. It was the victim's aunt. And some I'm not sure about the time frame.
So
I think it was a couple of weeks.
Pretty clear evidence of premeditation.
Well, if you're saying that the defendant had no way of countering premeditation, I don't think that's the case. I mean, I think jurors could have disregarded that. They could have felt that was just talk. I think the defendant.
let me put it to you this way. I mean, maybe it's not just talk, but if you say, you tell the aunt, I'm going to kill her, right? You encounter her on a public street in front of a whole lot of witnesses. You get into a fight. And that's when you kill her. It seems to me that if the jury doesn't have some explanation that, that he's not able to control his impulses when he's confronted in some kind of way, you're really not giving the jury any real alternative here.
I have to disagree. I think the jurors could take this. They could view this as. They could view the previous incident, even if they credited what the aunt said.
Why wouldn't they?
Because she's the victim's aunt. The jurors can take and reject any evidence that they want.
Of course they can, but I mean the aunt. There were plenty of witnesses, right? And the aunt's the circumstances in which the aunt, as I understand it, described this conversation is not. It doesn't have any of the indicia of a made-up conversation.
Well, of course, but jurors could take it or leave it. Jurors could take it or leave it. But I think that when you look at the circumstances, regardless of what he said 2 weeks before, jurors could clearly have found on the scenario of events here that the defendant didn't come there intending to kill her, and that's their defense.
And Ms. Semmer, as I understand it, the issue of her leaving him,
Yes.
that had occurred 2 weeks. I mean, that's what had triggered the conversation with the aunt, correct?
Yes, I think that's correct. I think he had moved out a couple of weeks ago at her request, and that had triggered the conversation. I think what happened in the street is he's asking her to take him back, and she's saying no. So it's not just a continuum. It could have been viewed as a fresh hurt, a fresh pain that caused him to commit the shooting. I don't think you can say on these facts that jurors just couldn't have convicted him of second-degree murder. I think that they could certainly, with everything that defense counsel put out there, including the heroin, including he marginalized Michael Pedrosa's testimony by eliciting evidence that he was concerned about his own prosecution, and he explained the events in a way that jurors could easily have rejected first-degree murder. And I think you have to weigh that. It's not a case that he didn't have a case of second-degree murder, and you have to weigh that against the mental impairment defense. Because I think, aside from Dr. Spear's report and what was wrong with that, I think it is potentially devastating to put malingering evidence in front of a jury, because you're essentially saying, I know I had no excuse, so I'm making one up, and it could destroy the entire credibility of the defense with a jury. And the tactical choice not to put that in front of the jury when I think there was a plausible second-degree theory is I think, a reasonable one. And it's one that that should not be second-guessed now, because I think it was reasonable under the circumstances it was made. This was a tough case. There are not a lot of good choices in this case, but I think that the one that counsel chose was not at all unreasonable. If there are no further questions, I'd be happy to rely on my brief.
Thank you, Ms. Semmel.
Thank you.